So I'm not going to introduce Brian because he'll introduce himself to say more about his background and what he brings to this. But over to you.
Okay.
So thank you very much indeed.
No, thank you. And I think I'm just trying to see how I pull these slides down. But no, it was very useful to get some background since it's a nice small group, perhaps to explain who I am and the sort of thing I do. I mean, I am an EU regulatory lawyer. I head the EU food and beverage practice at Covington. Covington is a international law firm, but it's actually quite a unique law firm in that its crown jewels, if you like, is not in the sort of corporate and M&A world. It's in the regulatory sector, and it's also an American firm in that it's based largely in Washington, D.C., which was the home of the Food and Drug Administration, which is back in 1918, where Covington was first set up to deal with essentially anything regulated by the FDA. So now that covers things like foods, drugs, cosmetics, and so on. One of our first ever clients was the National Canners Association, as it was back then in 1919. We've exported that practice to Europe. I'm based in London, but also have a foot in Brussels. We have a practice in China as well. And the focus, as I said, is on regulation. So I think we've got a very top-tier international regulatory practice. But what does that mean? And we've got some sort of law students and law professionals here. In my world, as a food regulatory lawyer, we're industry focused, but I suppose a lot of my practice would be what we call public and administrative law, because when you're dealing with regulation, you're often dealing with regulators, and they are essentially public bodies that you have to interact with and engage with. In some cases go through approval processes. In the food sector, you might need to go to the European Commission to get a novel food approval or a health claim, or you might be dealing with the FSA on a safety issue. Part of what I do would be obviously having a good understanding of the regulatory framework to help clients, and our clients are a mixture of industry clients. We also work for some universities, startup companies, and also in some cases governments. So we would help on the regulatory side, and in the worst case scenario, because I am a public law lawyer, and as it happens have rights of audience, I will go to court in Luxembourg typically to challenge decisions that haven't gone quite as our clients might have hoped in the General Court in Luxembourg. And there you're dealing with the European Commission, European Council, the legislature, European Food Safety Authority, and with a lot of our the kind of specialist work in the food sector, it's really been centralized at the European level. And when you're there and you've got a problem, all roads lead to Luxembourg. But that's not to say that there isn't that sort of work here in the UK as well. And we actually have one of the very few Supreme Court cases pending on a very interesting issue in the food sector, which I might speak just a little bit about. I think we got bumped because of the Supreme Court justices were busy with Brexit. But we will, in fact, represent our clients in the courts as well, and I do that, and I'm an advocate there as well. So it's a real sort of mixture, and I'm glad I'm able to, I hope to the lawyers in the room have an understanding of that end of what we do. But it's all industry focused, so everything we do, or I do, is largely in the food and drink sector, and I work with colleagues who might look at the pharmaceutical sector, and it's quite a nice mix because a direction of travel in the industry is towards things like functional foods and healthier foods and health claims, and actually there's a lot of overlap there and synergies with how pharmaceutical companies have had to operate for a number of years. So that, I hope, just tells you a bit more about me and the type of law I practice and where I practice. And it's given me a very nice perspective, I think, on Brexit, because on the one hand, I'd view myself as being very familiar with EU constitutional law and EU treaties, because I'm an EU food lawyer, so you have to know your way around EU food law. But also more fundamental concepts of EU law and EU rights. But because I'm an English solicitor and practicing in the area of judicial review, for example, have a good understanding of how the English constitution works, because whether you're in the Supreme Court in Article 50 challenging Brexit, or you're challenging a determination of a UK authority, the principles and the legal principles are the same. In English judicial review, you're challenging a public body on the basis that their decision is somehow unfair, somehow irrational, and that's quite a high standard. Some judges have said that the decision maker has to be temporarily unhinged for you to meet that threshold of irrationality. Or that the decision maker has abused their authority, abused their powers, acted illegally, or ultra vires. So those are sort of the general three areas you look at, and with the Brexit case, we're in that territory of the government allegedly abusing their power to issue the Article 50 notification under the royal prerogative. Anyway, so what I'm going to talk about today is Brexit, talk about the referendum and some of the timelines. I'll talk a bit about the case that is now very high profile. I think when I last spoke about this area with Tim, it was quite an exciting time, and it was a very nice opportunity to speak about it, because no one was talking about the Article 50 case. It just simply was not on the agenda. Lots of people saying, well, we're not sure when we're going to trigger Article 50. It's going to be this time, that time. No one was very sure. And people were saying, well, nothing much has happened over the summer. Obviously, in the background, we had this fascinating case that had kicked off. And so something was happening. And I think we were expecting the decision in a few days after I gave the last talk. And now it's obviously very high profile. And so it should be. I'll talk about the current position in terms of the regulatory framework for food law. I'll try to condense the myriad of post-Brexit models that have been discussed into a relatively simple framework, and then discuss about what those model-specific implications are for food law, and then try and just give some practical ideas and steps that people can take. Because a lot of people are asking us, well, what should we be doing now? What can we be doing? Is there anything we should be doing? And I think there are things that people can be doing to prepare themselves for Brexit and life after Brexit. So obviously we had a referendum where we voted to leave the EU. One of the key aspects of that and the referendum and the legal basis for the referendum was that it was advisory. It was not a legally binding referendum, and this is absolutely key in the Article 50 case, because the referendum did not provide a legally binding mandate to the government to leave the EU. It was advisory. It was like an opinion poll, some would say. And in some countries, people have referendums almost every week to talk about a whole range of things. But that's the starting point. It's an advisory referendum, and the UK overall voted to leave the EU. So what's happened since then, and how do we leave? Well, We know that the orderly way to leave is to trigger what we call an Article 50 notification. This is Article 50 of the Lisbon Treaty, which was the first time really that a process was put in place setting out how a member state could leave the EU. What we now know as a result of the Gina Miller case is that right now the government cannot issue an Article 50 notification because the court ruled that a vote in Parliament was needed before you could trigger the vote. And I don't intend really going into a huge amount of detail on the legal arguments, partly because absolutely fascinating. We've got a sort of 24-hour TV publicly funded transcript of absolutely everything that's going on in the case. It's fascinating. But one of the key aspects was the referendum was advisory. The government and the claimants accepted that you could not take back the notification. And these are aspects that would lead to at least a hollowing out of rights for some citizens, and there was a process in place for doing that under the European Communities Act, and the court at first instance said it was very clear that a parliamentary vote was needed. Now that has leapfrogged the Court of Appeal and is now in the Supreme Court. We're on day 3, I think, of the hearing, and we have 11 Supreme Court justices listening to it. It's obviously the biggest constitutional case of our time. Who knows where that's going to go? The thinking that we've heard is that the Supreme Court will uphold the judgment, but I've also heard that the Supreme Court is split on some of the issues, so we'll just have to see. But nothing can happen until at least the Supreme Court has ruled on that point. Other interesting aspects that are coming out of the debate include, well, you know, is Article 50 really irrevocable? Is that a settled question of law? If it isn't, then strictly speaking, the Supreme Court would have to refer that question to the Court of Justice for an opinion. Now that would obviously probably create riots on the streets if it was the Court of Justice in Luxembourg dictating essentially how our constitution should operate, but that's a realistic possibility. But I think people are preparing for a vote in Parliament, and that's where it will head. And I think part of the strategy behind this is clearly to, there's a lot of talk about the process and making sure that the process is right so that we get it right now and we don't mess up later down the line. But you can see that one strategy might be simply to frustrate the whole thing. Obviously, if a vote in Parliament is necessary, it raises that sort of ethical, constitutional question really for MPs: is do they vote with their constituents or do they vote with, the will of the majority of the referendum? And this sort of frustration perhaps could ultimately mean it's going to be very difficult to get the vote needed to trigger Article 50. We'll just have to see. But there's a 2-year notice period. These sort of terms are pretty well understood now. The UK has to try to define its terms of exit. You'll exit automatically after the 2-year period unless there's been some unilateral, not unilateral, unless there's been an agreement for an extension amongst the other member states. What we're hearing in the press is that there'll need to be a transitional period to get out of that cliff edge concept that we're hearing about. And that's obviously going to take a long period of time. commentators, myself being one of them, estimate you're looking at 8 to 10 years for that sort of transitional arrangement before you'd be fully clean of the EU. You know, you look at, I think it was Greenland is pretty much the only sort of benchmark in terms of leaving the EU, and I think that took several years, 6 or 7 years, to complete that process, and that was Greenland. There's obviously a tension here with the UK desire to access the internal market and controls on immigration and greater sovereignty. That's a sort of debate that's still ongoing. The EU, I'm fortunate because of our office in Brussels and some really splendid advisors we have at Covington, who include former EU ambassadors, former prime ministers. In the UK, we've got Lord Francis Maud as one of our special advisors. So we understand and have insights at the EU side, and obviously they're concerned about contagion, seeing what's happened in Italy very recently. The Dutch government seems to be in a bit of disarray, and we've got the French and German elections. We just had the Austrian elections, although that was quite interesting. So that's just, I guess, just trying to give a quick overview. It's difficult to keep pace with what's going on, but I feel that I can ground myself in the law and what's going on at the Supreme Court, and that's very comforting. But from a food law perspective, well, right now it's business as usual, at least from a legal and regulatory perspective. EU law will be binding on us until the moment of exit. But what about things behind the scenes sometimes in the interim? One quite interesting aspect that I've had cause to be involved with a little is the European Commission's investigation, if you like, into the UK's traffic light scheme. This was a scheme that caused a voluntary scheme in the UK with our traffic light labelling scheme that caused some concern, particularly in countries like Italy, where they viewed the scheme as a blocker to access to the market and an infringement of the principle of the free movement of goods. And the Commission opened its investigation into that, and they're looking, and still are looking, strictly speaking, at whether to go down an infraction proceeding route. This is where the Commission would take action against a member state, the UK in this instance, for infringing the fundamental principle of the free movement of goods. That had been a sort of a higher profile case that the Commission was handling until Brexit, and I managed to speak with some officials, the head of the food unit at the Commission at a conference a couple of weeks ago, and I asked about this. The case isn't closed, I was told, but it seems it's on the back burner since Brexit, because what's the point? It seems they've turned their attention to the sort of French equivalent of a voluntary labelling scheme. So you might see, you know, those sort of issues with infraction proceedings. You know, is there really an appetite to issue proceedings against the UK if we're going to be out in any event? Aside from food law, some of the interesting legal issues here will be, you know, the likes of Liam Fox going around sort of behind the scene negotiations on trade deals. We obviously, as a member of the EU, don't have the competence or the authority to negotiate or execute trade deals. We'll be able to execute them once we're out, and there's a question mark about whether we can even go around having these discussions with Australia, China, Korea. But you know, will the Commission really take that up in an infraction proceeding scenario? Probably not, but it might annoy the EU side of the negotiating table if we're making a big fuss of this. Likewise, you know, is there really going to be an appetite in the UK courts to refer matters of EU law to the Court of Justice? The lawyers here will know that if a question about a particular measure and the compatibility with the EU law comes up, the judge is obliged to refer that matter to the EU Court of Justice, just like the Supreme Court might be obliged legally to refer the question of whether Article 50 is irrevocable to the Court of Justice if that's a material factor. I say this because I am currently involved in quite an interesting case involving the what we call the borderline between foods and medicines. It's a very interesting area of law, particularly relevant for things like nutraceuticals, functional foods, and the issue is whether a particular food should have been properly classified as a medicine. And the case involves a substance called glucosamine food supplements that you can get in your local health store or Sainsbury's. And there is a complaint that's been brought against the UK medicines regulator about their failure to classify that category, which is quite a significant industry in the UK, as medicines, because there happens to be prescription-only medicine containing glucosamine at the same sort of dose or quantity as the food supplement. So that's a very interesting question. I'm acting for an interested party in that litigation, supporting the MHRA in that case from a food law perspective. Now that's gone, we won at the Court of First Instance. Technically the government lost in the Court of Appeal, or I like to think we won our points. The matter's now pending in the Supreme Court, and it's at that stage where we've said, well, really, this is a question of EU law and how EU law is being interpreted in terms of definitions of food supplements and medicines. But we had to file our permission for appeal to the Supreme Court, I think, about 2 or 3 days before the referendum, and we asked them to make a reference. You know, will they be inclined to do it? I don't know. But it's just some interesting aspects that we've had to think about as lawyers. So what are the post-Brexit models? Well, you'll have all heard about various types of model. I'm going to try to just distill the concepts down to a couple, which I've called the EEA model or the non-EEA model. And you know, how that will impact food regulation will depend ultimately on the model, and I'm not going to spend too much time talking about these with the tensions here, but clearly the Europeans, the EU side of the negotiating table, are very keen to ensure that if you get access to the single market, you have to bring with it free movement of people. Now, whether that's a deal breaker or not, or whether you can get access for certain types of market like financial services will remain to be seen. So the EEA model, one of the things about being a lawyer that I like is every now and then you have to do something new, and it wasn't until recently that I had cause to really read and get into you know, what the EEA is and the EEA agreement. But the EEA model, sometimes called the Norway model, is a model based on an agreement with the European Economic Area member states, which include Norway, Iceland and Liechtenstein, with the EU. And generally speaking, if you are sort of in that model, if you're part of the EEA, then you participate fully in the EU internal market, which means free movement of goods, services, capital and persons, importantly. But you have to pay into the club and you have to pay your dues. So what does that mean from a policy perspective? Well, some people have said it's all pay, no say, because if you're in the EEA, you actually have very little influence in developing policy and legislation. You don't get a seat at the table in that you don't have any members of the European Parliament, you have no vote in the Council, and although you can, strictly speaking, participate in regulatory procedures, you are sort of relegated to observer status. And this would be the case, for example, within EFSA. And one EEA member state, Norway, has said, when it comes to voting, we get to count the votes. We don't get to cast them. So that's broadly speaking what the EEA model looked like, but what are the implications of that for food law? If we can go down this Norway model, the single market approach, well, it's unlikely to be any material change, which is a very good thing from a food law perspective. You don't have this transfer of legislative power, so you have, to some extent, some sovereignty. But the EEA agreement actually requires the implementation of the bulk of EU laws, EU food laws. These are laws that you have not had a say necessarily in developing. And you can find those EU laws in Chapter 12, Annex 2 of the EEA agreement. So all the kind of pretty much laws we have on traceability, concepts of the precautionary principle, novel foods, health claims have now been, food labelling, implemented at the EEA level. That also means then that to the extent you have Commission-wide approvals, European Commission-wide, EU-wide approvals or notifications for particular foods like novel foods and health claims, you could continue to rely on those approvals in the UK. There might be some sort of administrative approval needed, like you have in some of the EEA member states. When a novel food is approved, you have a sort of automatic administrative step that's taken, let's say in Norway. And you'd also be able to use the UK as the sort of rapporteur with the European Commission and EFSA. You'd be able to use them as the country, the EEA member state, to support your application processes and so on. There'd be reliance on EU principles of free movement and mutual recognition, and quite importantly, the supply chain infrastructure would be largely unaffected, as would supplies to the UK. But as I said, the loss of influence due to observer status might be important, because you then don't have that say over the development of food policy and legislation. You're simply sort of thrust upon you as a result of being in this market. And obviously, importantly, it doesn't cover common agricultural policies, which can be obviously very politically sensitive. So that's the sort of EEA Norway single market model. What about anything other than that model, the non-EEA? Well, we've had various types of model that have been discussed. Swiss model being looked at quite closely, where you have a range of separately negotiated bilateral treaties with the EU. Switzerland has several, some of which require free movement of people. Although recently I was told by a Swiss lawyer that there is some sort of catch-all provision in these arrangements whereby if you don't comply with what some of the free movement principles, it has a sort of knock-on effect whereby all the agreements would come crashing down. And I know that there are some being negotiated or renegotiated at the moment, and Switzerland and the EU are looking very closely at the UK to see what happens here. We have the Turkish model, essentially some sort of customs union, and we have a sort of default model, WTO free trade approach, where the UK would simply be a third-party country with no preferential access to the EU unless there had been some sort of free trade bilateral agreement, and that's what I've said there. You'd need to enter into free trade relations with the EEA and the EU, negotiate these bilateral agreements on a case-by-case basis. If we went down a sort of WTO approach, then that would presume a total separation of the UK systems for food regulation from the EU. We'd simply be like the United States or Australia, and have to think about things like most favoured nation tariffs. Now, I'd happy to later on try to take some questions about WTO. It's a sort of very different regime, and again, being a lawyer, it's something that I feel in the future I will have to adapt to and become much more knowledgeable about how WTO operates, and because it's going to become much more important. So what are the implications for food law? Well, there'd be no obligation to implement new EU laws or maintain existing ones. But the general perception that I have amongst my peers, and I should say I'm a sort of committee member of something called the UK Food Law Group, which is comprises food lawyers in industry, private law firms like Covington, and also in government. And we meet every now and then to talk about topical issues, and we had such a meeting where we went around the table and talked at length about this. But the general perception amongst that group was that some of the mandatory EU food laws relating to production, so this is traceability, the hygiene, risk analysis, precautionary approach, labelling being very important, are quite satisfactory. So you'd expect and perhaps hope that any new laws would reflect already what we have in the EU. These are the mandatory food laws that we have. In particular, with thinking about something like food labelling, it was, I suppose, a little surprising to hear Theresa May at her Conservative Party speech when she was talking about, Brexit means Brexit. I think one of the two topics she picked out is, saying what we can do. One of which is we'll get a control on immigration, and we'll be able to control what we put on our food labels. And it was reaction was quite interesting because, and certainly from an industry perspective, you're talking about, millions and millions of pounds over a number of years to, get up to speed with the new EU food labelling rules, which still sort of coming into effect. So the thought of having to go through and tear up the book there when perhaps they're, quite adequate was very interesting. I genuinely don't know where a reference to the food labelling, food law came in. But what about other areas of food law? And maybe I'll try to be a little provocative here because I'm somewhat biased when it comes to this area. But things like health claims. And novel foods, and these are areas where innovation comes into play. And I think if we're going to make the most out of Brexit from a food law and a food industry perspective, I think innovation in that sector is going to be very, very important. Obviously, without compromising on safety and consumer protection, but I do think. In order to stimulate innovation and get consumers eating healthily and making the right choices, they want to know what the benefits are of the food, health benefits are that they can eat in order to switch. And there's countless number of surveys that have informed us of that. And The two areas, I suppose, that come to mind would be novel foods might be one, where you have, we've now got a new regime, but we've had a regime for 20 years or so that was there to regulate and put safeguards in place for so-called novel foods, but it was also there to enhance competitiveness. And in the 20 years or so since we've had the novel food regulation, we've only had about 90 novel food approvals, which works out at about 4 or 5 a year in the entire EU. That doesn't sort of spring to mind to me as being something that's supported and really driven innovation. It also costs a lot of money to bring a novel food to market. Some of the first novel foods, cost the companies behind them 24, 25 million euro, and that sort of money is just simply out of reach for small and medium enterprises, and it's the SMEs that are really driving innovation right now. So maybe there's something there that we can do in the UK. Health claims as well is a very controversial one. We have a health claims regulation in the EU. It was adopted 10 years ago now, and has put in place an approval process for health claims used on food, and was also supposed to bring in so-called nutrient profiles. Now, where are we with that? Well, one aspect of the health claims rules was not only to bring about consumer protection and try to be a harmonising measure, but it was supposed to incentivise R&D in this sector, in particular for SMEs. So in the 10 years that we've had that, and part of the mechanism there was to provide some proprietary protection for health claims, I think we've only had 5 or 6 innovative health claims approved off the back of genuine, innovative proprietary data. And that is quite shocking, I would think. And part of the problem is, of course, that it can be quite difficult to generate a sort of body of evidence to support a health claim. And it's also very difficult to in some cases, characterize the type of food or ingredient that you have to the satisfaction of 28 member states who might take a differing view about, what the composition of whole grain might be. And those are barriers to innovation, barriers to the ability to communicate to consumers. And I think we need to address that. We also need to be much better on the type of language we're using to express health benefits. The health claims regulation, and many of the claims are incomprehensible, and that's a problem. I'll give an example. Is a claim would be, this food contains homocysteine. Homocysteine levels are good for you, but no one would really understand what having high levels of homocysteine means. Now, we can certainly do better than, and we used to have a very nice sort of self-regulatory, cross-party regime called the Joint Health Claims Initiative in the UK, which was made up of industry, scientists, and enforcement bodies who would take a UK-only approach, and maybe that's something we can start thinking about. We have that sort of approach in Switzerland, for example, where I think DuPont have managed to get a claim approved in Switzerland for a probiotic, but those sort of probiotic claims, you just don't see them in the EU because of, in part, problems over how you characterise probiotics, as a food lawyer, it's been quite interesting. You've seen the word probiotic almost erased from the dictionary. Traditional regional foods. So we like our Cornish pasties, we like our Stilton cheese. Now, I think you're going to have to find some sort of grandfathering arrangement or reciprocal arrangement to ensure that you can continue exploiting those names. And Codex is obviously going to be hugely important. Codex, as many of you will know, is absolutely key at the international level to driving policy guidelines and standards. And you know, a lot of that has been harmonized to some extent by Codex. So maybe it won't be too much work there after all, but I do think the government's going to need a real education about Codex, because it will be in the driving seat there from a UK perspective, won't be able to rely or take a back seat as it might have done at the EU level. So summary, we don't really know whether UK will Brexit and what the outcome will be if it does. We're all kind of planning for a Brexit, and we have been. I mean, there's not much you can really do, but you can do some sort of contingency planning. You could, for example, identify things like existing pending future applications or notifications that would typically involve some EU institution, novel foods, health claims that are managed by the UK, check the timing of them obviously, and frankly consider using alternative member states as the sort of rapporteur if you need to, because otherwise there will be some sort of administrative hassle later on, regardless of what model we take. Labelling and establishment issues. The food business operator, at least for labelling purposes, should be in the EU. You should check your labels, perhaps identify what products you have with the UK listed as the EU food business operator. Some products have a particularly long shelf life. I know, for example, food supplements can last 2 or 3 years, so just might need to at least be thinking about that and have those identified. Are UK entities participants in an EEA supply chain? If so, you should probably at least identify the contracts that are in that supply chain, see what the leading time is to have them changed if necessary, so that you can ensure the EEA supply chain works for you. Obviously, if we're outside of the UK, that could be a problem depending on the model. A lot of that is often, though, driven by tax considerations as well, so that will be important. You might want to consider establishing greater links in other EU member states so that there is a voice. That's just not an industry concept, but that applies very much to academics as well. The one other thing which isn't on this slide and that I've just been thinking about recently is exporting issues. We have the government is now pushing an export agenda, and it will be important to perhaps start thinking about what markets would be of interest to industry as a food business, and start thinking what the barriers to entry might be in those markets. Think ahead so that you've got sufficient time and you can do efficient planning. And I think that is sort of just about it for a whistle-stop tour.
Very good. Thank you very much. Thank you very much. Now, I mean, can I throw a question to you
Sure.
right from the end to get us going? The issue of Codex is of particular interest to me. I did work 26 years ago looking at Codex, and Codex then was about 2,700 participants from over 120, 30 countries then. We're now 164, plus some observers. Also, one-liner on Codex belies immense complexity. I'm sure you know that. What lies behind me pointing to that is that I can't remember when we last met whether we had this discussion, but I think the most likely scenario is actually as Britain is out. because unless there is flexibility on freedom of movement of labour, which is the big issue behind Brexit, it's highly unlikely that some agreement will be done of a EEA sort. I mean, it's possible, I'm not saying it's not likely, but certainly the insiders I know are talking about it as maybe be 20-30% likely of doing a deal. Depends what happens in French elections, the Hungarian Visegrad group, Netherlands, all of that. The politics may change. But even so, it's very hard to get that. In which case, the most likely is being out. In which case, things like codex become not peripheral. They become fundamental.
Yes.
You'll be dusting down all of your codex procedures and so on. I mean, are the food lawyers, the circles, the European Food Law Group you mentioned, are they beginning to think, and we're in a plan B, are you preparing for the plan C, which is that world?
Yes. I mean, I've had to adapt and be thinking about adapting to meet client demands. A few interesting points, I suppose, is that no one thinks too much about the impact on poor old lawyers, but we are English qualified lawyers here. We do a lot of work on EU investigation-like matters, so anything involving an EU institution, if there's an investigation, we'll be involved. And obviously one of the benefits with being an EU lawyer is that you attract EU privilege over the advice we give to our clients, but that only applies.
Audience rights.
That's right, Europe. Exactly, and rights of audience in Luxembourg, which is where we spend quite a bit of time. There's been an absolute swarm of that type of lawyer qualifying in Ireland as an Irish lawyer, so that when the time comes, particularly where you're involved, some of these investigations and court cases, access to justice at the European level is very slow. You're talking about 3 years at the general court level, and we want to make sure we maintain our rights of audience and also privilege for our clients. So, one aspect there is just having to get qualified in Ireland to make sure that we have and can maintain that sort of privilege. But the other will be adapting to the new world order, and I think being much more trade focused and absolutely having to brush up on codex and the codex procedures and the regulatory framework for that. That's an education not just for us as lawyers, but for our clients and industry, and importantly government. I was at, I don't know if you were at the Food and Drink Federation seminar on Brexit at the British Library, and it was, I'm not sure if they'd even heard the word codex.
Well, it was me who asked the question
okay.
of the head of the department and said, what is your line on codex?
Yes.
And she didn't even know what it was.
Yes.
That's partly what was behind my question. For those who don't know, essentially the British, because we're members of the European Union, we deal with codex as the EU. Gradually over the last 20, 30 years, EU has become the channel through which codex is done. And that raises, actually, I don't want to hog it, but it raises a second question. You and I talked about it, which is the issue of capacity. We haven't got, you're a lawyer in London, you're working for big corporate clients, but think of yourself as a voter and a taxpayer. I am scared witless by the weakness of my state. It has very little capacity about this. I just flagged that. But have we got any other questions?
Questions or comments? I'd be interested to hear.
Questions and comments. Can you speak of this? It's only recorded. Can you say who you are and where you're from?
Yeah, please. Tony Lewis, Chartered Institute of Environmental Health. In terms of banana skins that are on the way, to a Brexit decision. I wonder if you could confirm something that I at least understood. That as well as the stages that you've already outlined, there were two additional ones that are over and above any parliamentary vote, that before negotiations can begin, the European Commission itself must seek a clear mandate from the European Council, without the UK being present, on the commencement of negotiations.
Yeah.
And in addition, that once the draft withdrawal agreement is in place, that needs the consent of the European Parliament. So, as I understand it, those are additional banana skins that are
yes.
on the way to a Brexit decision.
Yeah, no, it's, you're absolutely, I mean, I can throw maybe another one in there. You're absolutely right. My understanding, very recent understanding, again, leaning on some of my colleagues in Brussels, is that it will be the Commission primarily who will conduct the negotiations, even though it should really be the Council. And there's a bit of tension there, with the UK obviously trying to be dealing with the European Council, because there are issues, let's say, I suppose, with the Commission. But you've identified exactly the right steps. The one banana skin that I probably didn't mention, and again from sort of very recent insight the last week or so, and one that is seriously contemplated on the EU side, is we go down the Article 50 route. We assume we get some sort of parliamentary approval or whatever, or the Supreme Court says we don't need it or whatever. We go down the Article 50 route. It becomes clear, let's say, that we're going to come back with something that is unpalatable to the folks who, hard Brexiters, and that puts us into a position where we just abandon Article 50 altogether and leave unilaterally, and would simply no longer become a member state of the EU. Now, what would happen there is that the matter ultimately would lead to the International Court of Justice in The Hague, and we'd be UK versus EU, dealing with things like, well, what's the financial liability? How much do we owe them?
And do you think that's likely?
I hadn't even contemplated it until I'd heard that the EU people at the council level are preparing that, and they believe it's a realistic possibility.
Yeah. Well, I'm sure. Do you want to come back?
No, just confirm that.
Even speaking to that.
Yeah, no, I don't need to come back. It's confirmed what I thought. But the interesting one is the very, very hard Brexit that you just highlighted. We walk away and end up taking on the entire community in some protracted legal case that runs and runs and runs.
This is the environmental health officers. What's your understanding of that?
That would be absolutely scary in all respects. In other words, where would we go in terms of a food law?
Yep.
You talked about EEA models, non-EEA models.
We
wouldn't have any of those options that would be open. We'd be up against something else.
We'd be totally out. So you'd be sort of at that WTO level where the UK is sort of somewhat in the WTO by itself and somewhat in through the EU, and you would have to, as the UK, negotiate your own schedule of tariffs, which is something that has to be adopted by consensus amongst the 160 odd members of the WTO. So if you've left unilaterally and you've already annoyed the EU, that's one sort of institution that's going to be difficult to deal with. If you're Argentinian, you have an issue with the Falklands, there's another. And if you're Spanish and you want Gibraltar back, that's another. So, very interesting political aspects. And I think there's been a round, the Doha round. I'm not a WTO expert, but the latest round of sort of negotiations is still ongoing. It was Doha, and that kicked off in 2001. So we're 15 years in.
Matthew Warman from Harcourt. I was wondering if you'd had any time or chance to think about the wording of the Great Repeal Bill, which in theory will come in after March of next year, and which will sit on the statute books until 2 years after March when we leave, which essentially will flick all EU policy into UK policy, flip up the switch as it were. I was wondering in particular, because Andrea Leadsom has said recently that she says between a quarter and a third of environmental legislation we will want to take a look at, and between a quarter and a third we may want to change without giving particularly good reasons as to what the rationale behind those changes. I think a finger in the air is probably the answer. So between a quarter and a third, all this legislation can be up for review. In which case, who will decide? Will it be the government? Will it be the executive? Will it be the legislative? What will the opportunities be for people like us to influence that process? How will that run in parallel with the various negotiations that we're having with the Commission at the same time? I mean, it's obviously a long way off, and it's dependent on December, and it's dependent on the Article 50 announcement, but that's going to come up very, very soon afterwards.
Yep.
And I was wondering if you had any thought about the wording of the Great Repeal Bill.
Well, I mean, clearly, I think there's going to be opportunities to get your message across, and one hopes that the government will listen and go through a listening phase. I mean, in terms of what will be in it from a food law perspective, what I've heard on the grapevine is that, officials within, let's say, DEFRA, FSA, DH, the sort of terminology I've heard is, well, let's take a copy and paste approach.
Plus the delete button.
So the question is, well, what do you delete? And I think it probably, from just an efficiency perspective, makes sense to, in a way, try to lump everything in and then go through a process of tweaking, deleting, taking out, and perhaps thinking about whether we really need it. We have a sort of system of legal principles in this country that, if something isn't prohibited, then you can do it. Sort of different concept on the continent, where you almost need to be told that you can do something in order for it to be legal. That could be an opportunity to, cut through a lot of red tape or just unnecessary bureaucracy. But I think you have to start with putting it all in, so that you know what you have, and then listen to the various sectors to understand, how and what you do with it.
Matthew, do you want to come back? Tony wants to come in. I wouldn't mind.
No, please.
Tony, do you want to come in?
Yeah, just a quick one. In relation to the repeal stuff and indeed diminution of standards, again, look at what Jacob Rees-Mogg has said today, quoted in The Independent, and talking about a wider bonfire of regulations, specifically in relation to environmental protection, but also health and safety, with the quote that the standard that we should adopt is, if it's good enough for India, it's good enough for us.
India.
Labour standards.
Imagine Friends of the Earth is going to have some fun here. The comment that I'll make is, because I, like everyone, is extremely interested in the Great Repeal Bill. My understanding, correct, you probably know better than this, Brian. My understanding is it started off as 4 pages, but now it's very large indeed. And to the point at which, I think when you and I were at the FDIN meeting, this seemed a crazy idea. I was then thinking there will have to be a Food Act.
Separate act, yeah.
Separate act. That is now rocketing up the agenda. Because as the lawyers, your good selves, that inside Whitehall have got into the Great Repeal Bill, it's become more and more clear that food accounts for 40% of EU law.
Yeah.
Therefore, just rolling it into the Great Repeal Bill, there may be some clauses which cover it, but there will then have to be enormous legal, not just implications, but legal tightening up under a Special Food Act. And my understanding is that DEFRA is working now on potential Food Act and a potential Environment Act. So the two bits of Vicky
An Environment Act.
and an Environment Act.
And not an Agriculture Act.
Not an Agriculture. So that this is all, who do I know? This is as good as people I've talked to in the last week.
Yes,
but
yes.
It is interesting. And the second point to comment on Matthew's question is back to something Matthew and I have talked about, which is this problem of capacity. My point I made about codex, have we got the capacity in the British state for a public lawyer? The British state is incredibly weak when it comes to food law, and that troubles me greatly. So the focus is all on the Great Repeal Bill, but not upon what breathes life into skeleton's the wrong word, but into the embryo. So I think this issue, we shouldn't get too fixated on the repeal bill. It's actually what's behind it and what's after it and what would allow it to be take life. I think we're not giving that enough attention, we outsiders. And I think government is getting more and more worried, is my understanding. Sorry, in civil service and lawyers around it. I think that the final point I'll make is that we're assuming the government is unified. It isn't. It's hopelessly split. And this is one of the areas in which there is major split between ministers and between DEFRA ministers and the trio who are nominally in charge of Brexit, let alone the Prime Minister. So this is the world of politics, not the law, but it's where the interface between law and politics comes. So I've said it to you before, I think there's going to come a point when you lawyers, your European Food Law Group, will have to be slightly noisier than you've been. I think when you and I met originally, the food industry was keeping its head below the parapet. It's now coming out. The letter last week, initiated by the National Farmers Union, is I think is the beginning of that process. And I'm privy to some very, very large companies who did not want to sign that letter because they wanted to, I'm sure you know, that they didn't want to sign that letter because they would have liked it to have been done by the sectors rather than by names. So I think there's going to be a room for us as citizens to be a bit noisier, not just to observe, but to say, now hold on, this is no longer a political game, it's very real. Does anyone, Matthew, do you want to come back?
I mean, I was wondering what was interesting what you were saying about the Food Act. Are you saying that the Food Act is necessitated by the repeal bill in order to put this legislation into a safe, manageable box for the future? Or are you saying that people are seeing the repeal bill as this Jacob Rees-Mogg opportunity to take a long, hard look at our food policy?
Well, I don't think Jacob Rees-Mogg should be sort of top of our identity, but he's a very useful indicator because he's noisy, he's clever, he's fluent, and he speaks out. So at least you have the honour of knowing what he's thinking as opposed to not knowing what people are thinking. I mean, there is a spectrum of political opinion. You know, John, more than any of us in this room. But no, my point was a more prosaic one, which was that just the Great Repeal Bill cannot deal with the complexity of food. It's not up to the job.
Yeah.
And the lawyers, my understanding from DEFRA and others, is that the lawyers advising DEFRA are now saying that to them, saying this cannot resolve what it needs to be resolved. Is that clear? Brian, what's your point?
I mean, I was going to say it's, again, if there's especially lawyers or law students in the room, I mean, food law is one of the most complex and challenging areas of law. I started life out primarily as a pharmaceutical lawyer, and you know, everyone thinks that's pretty complex, but it's nothing like as complex as food law.
Next.
Hi, yes, Bridget Henderson from United Union. Just going back to one of your points from your slide about the general perception by the UK Food Law Group that the current mandatory EU food law requirements related to food production, that the view was that they were satisfactory, so that they were likely, new UK laws would reflect those. That doesn't, given what's just being said, that seems a bit optimistic.
Well, I suppose from a legal perspective, we have, you know, let's say industry. You know, an industry knows and perhaps is comfortable with you know, what it knows. Better the devil you know, I suppose. And where you've invested, in particular in food labelling, millions and millions of pounds. I think I've heard it was cost on average between £3,000 and £4,000 to update a label, a food label, and then you multiply that by however many brands or products you've got to update. You're in significant, you know, that, and it does the job. And actually, our system of food safety is very well respected. So they didn't seem. I think I mean, I don't want to overdo it. It was more of a sort of, we had a little vote and we chatted about it, but it seemed that they were fit for purpose, and you know, they were very well respected internationally. Why change them? Why change them? And you know, obviously we still have to. You know, we'll be dealing with the EU, and you know, if you are trading with people, let's say like Ireland, one of the biggest trading partners, who will need and expect products imported there to comply with EU law, why fix it? My point, as it happened at that meeting, was that there might be opportunities in terms of some of the more voluntary aspects of food law to do something different. And you know, I think you just have to look at the facts in things like novel foods and health claims to see that we're not getting the innovation perhaps that was initially envisaged. It's very clear we need to keep consumer protection at the forefront and consumer safety. As it happens, we have perfectly adequate laws in this country and in Europe to deal with misleading advertising. It's enforcement that is the issue, and it was enforcement across the EU and different attitudes to enforcement. So maybe there is something we can do in that space to, you know, deregulate, delegislate on health claims, whilst ensuring that you know, companies who want to be able to communicate and take the benefit of that sort of communication comply with very high standards of safety and evidence generation. And there might be an opportunity there. That was my take on it.
Sure. I was actually, like Bridget, I was surprised you said that. You're not the first person I've heard say that. Various people in the food industry, to quite very senior levels, have said that that's the area they think they would like the delete button. And I'm surprised by that, actually, because I think it might, while I understand it could be short-term gain for their members, actually it walks straight into the difficulties that we had in the 1980s and 90s in Britain about food safety and public confidence. So you know, I'm a policy person, so I would say this, wouldn't I? But I would think that would be very short-sighted or short-termist. Just to give one example, if nanotechnology develops, this must be across your horizon. Whoa, can I see legal problems about, declaration of did I know that this thing that's so small that it can go from my stomach right the way through to my kidney has been put into my food and not declared. I mean, cool, as we say in policy. This is a different order. And it won't take long before Friends of the Earth or Greenpeace or whatever who are in the room are saying this is unacceptable. We've already got that actually in America, funnily enough. You just have to look into where this sort of the functional food and where the nanotechnology developments are happening in Japan and the US, and to know that actually there's extreme concern from consumer organisations and indeed public health.
Yep.
So I think it's not, you weren't saying that's what you think, but that's what the food industry is saying. And I think of all areas to go for a delete button, that's the one that I would be very nervous about.
Yes, well, nanotechnology, very, very interesting the approach food law has taken with nanotech. They've introduced concepts into legislation, which, it's an area that is moving very quickly in terms of what on earth is a nanoparticle, what's the definition, and...
it's not just, sorry to interrupt, you're right, you're the good lawyer here, what's the definition, can we get it down in writing? It's my always love talking to lawyers, you're so precise, but actually it's what they do that's the issue, and the danger is that the law gets caught up in the definition and the process and the ratification, but forgets this is food. And this gets incredibly sensitive.
But we've,
You're a father.
Yes, I'm a father of four young kids. But from a food law perspective, I think there's flexibility in the system to ensure, with the right checks and balances. And in the food sector, there is actually quite good risk assessment guidance for nano. In contrast, let's say, to the medicine sector, where they're taking a very different approach to nano because they feel the risk assessment process deals with that. But we have, embedded in the EU system this precautionary principle approach.
I was very interested, I don't know if others in the audience, that you specified that sort of 2 or 3 times. I think you're right. It's something that is sort of bête noire to the Jacob Rees-Moggs and the sort of the hardline right wing. But actually, again, that's something that one should be careful about throwing out, because otherwise you throw out the baby with the bathwater. It is about retaining consumer confidence. That's what it's all about. It's not just science, it's a principle of public protection. Can I raise one other point, because we're sort of getting towards the end of our time. You as a lawyer, and you come from the High Court and reminding us of the Supreme Court case going on at the moment, the hearings going on at the moment. We get the results in January now. The thing that has raised a lot by the whole Brexit and food law issue for me is an issue of institutions. If you just look at how many institutions of the state we refer to, and you refer to, from Codex to WTO to European Court of Justice, you're looking at exactly. These are enormous. EFSA. And we are entirely dependent upon the pooled scientific knowledge through joint research, the JRC in Pharma and the European Food Safety Authority and so on. What do you think about that? Where are you going to get the benchmarks, not you, but where are we going to get the benchmark scientific judgments and that are supposed to inform what institutions do to protect consumers from what goes into their mouth doing them harm?
Yeah, my comment on that is, I think a lot of people, let's say, if talking about the sort of scientific and standards and benchmarking at EFSA, rely very much on the sort of excellent academic food scientist expertise that we provide to them. and they will lose the benefit of that. And it's not just a food issue, it's, you know, a pharmaceutical issue, it's a chemicals issue.
Well, we host the European Medicines
Agency yeah.
here in London. I mean, it's
we won't anymore.
Thinking it's packing up.
Yeah. That's the one certainty, is that the EMA will have to...
Yes, that is one certainty. On the food front, it's more that we will enter a period of deficit. We will have nothing.
Yes.
And I think, I mean, it's not a question to you as a lawyer, but I was just wanting you to comment. I think that's very serious politics. I mean, I think that's a big issue in the Chartered into environmental health with the food law enforcement officers, as you know, at the local authority level. And no one is thinking about that yet. No one at all.
I mean, I'd be interested in comments about, I mean, it's always, I find, particularly when advising clients who are not in the UK, saying that we've got, you know, just within the UK, we've got DEFRA, Department of Health and Policy, FSA, and it's kind of shocking, or comes as a very surprise to them that you have to deal with so many different regulators on a particular issue.
So DEFRA is hiring like mad, I'm sure you know.
And asking for a lot of voluntary support.
Plus a lot of voluntary support.
No, we're not.
But there are companies supplying like mad. Yes, one more question here.
I just wanted to, I think you heard from the Sustain Alliance for Better Food Farming about 80 NGOs concerned with food farming issues. And I had several points, but I won't read them all. But one issue I did want to ask about was the recall system, whether you've talked about that at all, and, you know, sort of, when you've had scares, what's going to happen in those situations. The other one was pesticides and pesticide residues. I don't think you mentioned, but that's an issue. Obviously, it's got wider implications. Pesticide use is a big environmental health issue, but residues and authorisation of pesticides and those chemicals within the food system. I wondered if you talked about that to all your colleagues and whether what the changes are going to be on that. And my final point was related to that, and I mean, I just sort of put it out there, which is GM. You talked about liability, and, you know, we've had a massive process of discussing coexistence of GM, genetically modified crop technology, against non-genetically modified and cross-contamination. You know, and that got me thinking while I was sitting and thinking, well, these kind of things aren't going to be stopped by borders. Obviously, the only real border we have in Europe is Northern Ireland. But it's many of these things to do with environment and food production are cross-contamination is very, very possible. So, I suppose that's just a comment, really. How on earth are we going to cope? But the first two, I'll be interested in your thoughts about those.
Yeah, well, I mean, just quickly on pesticides, it is the one is one of the areas that I have heard on the grapevine that the UK is looking to perhaps change or take a, you know, press the delete or thin it out. That's, I mean, I've just heard that.
So removing the precautionary principle?
Well, I don't know. I mean, if this is sort of corridor talk.
It's one of the issues, I agree too, I've heard that too. It's one of the issues the National Farmers Union has campaigned very strongly. So, which will not be a surprise to
very powerful lobby. Very powerful lobby.
Brian, I was interrupted.
No, I think that's the only sort of, unfortunately, the only comment I had there. But it sounds like there is, you know, that's something being thought about.
Well, they've been the issues specifically about REACH, the application of REACH, the chemicals system, but also the big rapeseed oil farmers were extremely unhappy.
Yes.
Well, lots of glyphosate and then the neonicotinoid bans, and those are very much coming from Europe. And so we're likely to get, I think you're right in the pressure will be very strong, the lobby is very strong to remove those restrictions. But I think there'll be a big backlash for consumers and those using the wider farm environment.
I presumed when you, Brian, said about the Mrs. Neeson's figures, when we were discussing wherever those figures, wherever they come from, I think that's actually the effectiveness of a particular agricultural perspective.
Interesting, yeah.
Being amplified a bit.
Yeah.
And there may very well be people who've done the homework and done the calculations of how many things that the legal document is being imposed over. But this is only putative, we have to remember.
Yes.
Even if you were actually there in the process of doing that, and it wouldn't surprise me if that figure came from them, because they seem quite pleased with it. And that's environmental policy.
That is very interesting. I didn't know that.
I think on recalls, I think I mean, my sense is there would have to be at least some international cooperation on recalls, much like there is today internationally, but you wouldn't have that sort of legal obligation to cooperate as you now do. We have a principle under the EU law of sincere cooperation. And
that work with Horsegate, or was it just the horse meat one, or was it?
Well, the problem was, that's a good point. The kind of recall issue is really geared towards dealing with safety aspects. Of course, there's nothing really wrong from a safety perspective with eating horse meat. It was a labelling issue, and that's where it opened up a sort of gap, both from an enforcement and legal perspective, about how do you really enforce and take down food fraud. And we obviously have a bespoke regime now in the UK, but prior to that scandal, you were having to think about prosecutions under the common law of fraud and misbranding.
Okay, look, we've got to our allotted time. I'd like you to join me in thanking Brian very much.